When businesses think about customs duty, they usually focus on three things: the product, its country of origin, and the tariff classification. But there's another area that's often overlooked: royalty payments. For many multinational businesses, royalties are simply seen as a finance or tax issue. However, under customs valuation rules, some royalty and license fee payments may also affect the customs value of imported goods. And if they do, they could change the amount of duty that's payable. So, how do you know when a royalty payment should be included? And when doesn't it have to be? That's exactly what we'll explain in today's video. Welcome back to Ask the Customs Manager. If your business imports products from related companies or licensed manufacturers, understanding how royalties interact with customs valuation is becoming increasingly important. Many businesses have well-managed transfer pricing policies and royalty agreements, but customs valuation follows its own legal framework. And that's where confusion often begins. A payment that makes perfect sense from a tax perspective doesn't automatically receive the same treatment under customs rules. Understanding the difference can help businesses make better decisions and avoid costly corrections later. Let's start with the basics. A royalty is generally a payment made for the right to use intellectual property. That could include a brand name, a trademark, a patented technology, a manufacturing process, software, or even copyrighted designs. For example, imagine a company imports branded footwear. The manufacturer produces the shoes, but the importer also pays a separate royalty to use the brand name. The question customs authorities ask is simple: is that royalty connected to the imported goods? If the answer is yes, customs authorities may need to consider whether that payment should form part of the customs value. This is where many businesses become uncertain. They often assume the commercial invoice tells the full story. But customs valuation isn't always limited to the invoice price. In certain situations, additional payments made by the buyer can also be relevant. That's why customs authorities don't only review purchase invoices. They may also look at license agreements, royalty contracts, transfer pricing documentation, distribution agreements, and other commercial arrangements to understand the complete transaction. For businesses operating internationally, this highlights the importance of keeping finance, tax, legal, and customs teams aligned. So, when does a royalty actually become part of the customs value? And what questions do customs authorities usually ask before making that decision? Let's look at the key principles next. When do royalties become part of customs value? So when does a royalty actually become part of the customs value? The answer isn't simply yes or no. It depends on the facts of each transaction. Under the WTO Customs Valuation Agreement, customs authorities generally look at a few key questions. First, is the royalty related to the imported goods? Second, is the buyer required to pay that royalty as a condition of selling those goods for export? If both of those conditions are met, the royalty may need to be included in the customs value. The assessment always depends on the wording of the agreements and the commercial arrangements between the parties. That's why customs authorities don't rely on one document alone. They review the bigger picture. Let's take a simple example. Imagine a company in the UK imports branded sports shoes from a manufacturer in Asia. The invoice for the shoes is paid directly to the manufacturer. Separately, the importer pays a royalty to the brand owner for the right to sell those products under a well-known trademark. At first glance, these look like two separate payments. But customs authorities may ask an important question. Would those shoes have been sold without the royalty agreement? If the royalty is directly linked to the imported goods and forms part of the conditions of sale, it may need to be considered when determining the customs value. Every case is different, which is why businesses should review their contracts carefully, rather than assuming all royalty payments are treated the same way. One of the biggest mistakes businesses make is assuming that finance and customs operate under exactly the same rules. They don't. Another common mistake is failing to share royalty agreements with the customs compliance team. In many organizations, those agreements are managed by legal or finance departments. As a result, customs teams may never see them. Businesses also sometimes update transfer pricing or licensing arrangements without considering whether those changes could affect customs declarations. These situations don't automatically mean a company has made an error, but they do highlight why communication between departments is so important. So, what are the practical steps? Start by identifying whether your business makes any royalty or license fee payments connected to imported products. If it does, review the agreements alongside your customs valuation process. Ask yourself, who receives the royalty? What is the payment for? Is it connected to the imported goods? Is the payment required before the goods can be purchased or sold? These are the types of questions that help businesses understand whether further customs analysis may be needed. For multinational companies, it's also a good idea to ensure customs, finance, tax, procurement, and legal teams regularly share information. The more complete the picture, the easier it is to make informed customs decisions. Royalty payments don't automatically increase customs duty, but they also shouldn't be ignored. Each arrangement should be reviewed on its own facts, taking into account the relevant customs valuation rules and the commercial agreements involved. Taking time to review these arrangements before an audit is often much easier than trying to correct them afterwards. A proactive review can help businesses improve compliance, strengthen internal processes, and reduce uncertainty when managing international trade. If your business imports products under a licensing agreement or pays royalties connected to imported goods, now is a good time to review how those payments fit into your customs valuation process. If you found this video helpful, subscribe to Ask the Customs Manager for more practical guidance on customs valuation, international trade, and global trade compliance. You can also visit customsmanager.org for articles, webinars, and additional resources designed to help businesses strengthen their customs compliance programs. Thanks for watching, and we'll see you in the next video.